Okay, there we go. We are going to go through this one together because the first portion of it is a little bit confusing, and I've had a lot of people from my other classes not understand it and do it completely and totally wrong. So I want you guys to do it right. What you do for this, so you read the background of the case. In this case, there are only 3 cases. With the martial court means that the court was under the direction of a guy named John Marshall. He was the Supreme Court justice, head justice. So it doesn't mean that his vote counts any more than anybody else's, but he is the one who's in charge of making sure everything in the Supreme Court goes the way it's meant to go. So what John Marshall does is he's going to create precedent, which is like traditions that are going to be followed. He's going to create precedent for the judicial branch to actually do what the judicial branch is meant to do. And what the judicial branch is meant to do is check the other 2 branches. The judicial branch is there specifically as kind of like the watchdog. They are, if the legislative branch does something unconstitutional, the Supreme Court handles it. If the executive branch does something unconstitutional, the judicial branch handles it. If there's a conflict between a state law and the U.S. Constitution, that goes to the Supreme Court. It is the place that keeps the Constitution regulated and keeps the states from overstepping their bounds and breaking the Constitution. So in these 3 cases, we see that start developing. Marbury versus Madison is the first one, and McCullough versus Maryland is another, and then Gibbons versus Ogden. Marbury versus Madison. I'm going to read this to you guys just so that I have it on the recording, and then we'll go into the constitutional question and the SCOTUS ruling. And SCOTUS just means Supreme Court of the United States, if you didn't know that. So William Marbury was a Federalist, had received a midnight appointment to be a judge from President John Adams. When President Thomas Jefferson, an anti-Federalist or a Republican, took office the next day, he ordered his Secretary of State to not deliver the commission to Marbury, preventing him from assuming his position on the court. Marbury asked the Supreme Court to force Madison to deliver the commission. So Marbury is trying to ensure his position on the court. He's trying to ensure that he gets paid for the position he was hired for by John Adams. Well, what John Adams had done, it's not necessarily he had more of an advising role, not necessarily one of the court system roles. So it is up to Thomas Jefferson whether he keeps him on or not. So constitutional question, and this is the part that tricked everybody, because everybody's trying to think of, okay, well, how do I phrase what the constitutional question is? You don't have to, because if you scroll down, here are the 8 possible constitutional questions. All right, and you look through them and you say, okay, did the Supreme Court have the right to award judges commissions? Well, we're looking at judges and we're looking at commissions, so most likely that one goes right there. All right, then we'll say, okay, are there any others that go over here? Let's go through, check them out. Does the U.S. Congress have the power to create, open, and operate a bank? We're not looking for that. New York State grant a monopoly? Doesn't make sense. Did the federal government or state government have the right to regulate interstate commerce? That doesn't deal with us. Can governments interfere with operations of a national agency? Can they tax federal agencies? Marbury. Did Marbury have the right to the commission? Oh, wait, I'm not going to copy that. I'm just going to drag it up here. That'll make it easier on us all. All right. Now, each of these will have about 2. A couple of them have 3. That is all of the constitutional questions that have to do with Marbury versus Madison. Then you do the same exact thing for the SCOTUS rulings, the Supreme Court rulings. Come down here. All right. New York State doesn't have anything to do with us. The Supreme Court had been given the power to grant commissions to judges by the Judiciary Act of 1789. However, this law, the Judiciary Act, was unconstitutional according to John Marshall. So we talk about judges and commissions. So that's going to go in Marbury versus Madison. Flip over here. Let's go through and look some more. Power to regulate interstate commerce doesn't have anything. Maryland doesn't have anything to do with it. This case established the concept of judicial review, the idea that the Supreme Court had the right to declare laws constitutional or unconstitutional. That goes up here. So, judicial review, and that's the last one for Marbury versus Madison. Judicial review is going to be the big thing that comes out of this court case, because it gives legitimacy to the judicial branch, and it gives the Supreme Court the right to declare a law unconstitutional or constitutional. It also sets up the Constitution as the law of the land. So you cannot create a law that goes against the Constitution, and if a law goes against the Constitution wins out every single time. It was a very, very important ruling, one of the most important that the Supreme Court has heard, because without this case, the Supreme Court and the judicial branch wouldn't have the oversight that they have today. Does that make sense? And does what I'm doing make sense, or am I going too fast? Do you guys have any questions for me at the moment, or do you want to keep going? I'm going to take the silence as a keep going. Oh, there's nothing in the chat. All right. McCulloch versus Maryland. In 1816, Congress chartered the Second Bank of the United States. The bank wasn't popular among Americans who felt that it was an example of the federal government abusing its power. In 1818, the state of Maryland passed a law to tax the bank. James McCulloch, a cashier in the Baltimore Bank, refused to pay the tax. So then we come back down here. So we know anything that has to do with a bank, taxing a bank, or Maryland, that's going to be one of our constitutional questions. So this it's really a lot of common sense kind of stuff. So does the U.S. Congress have the power to open and create and operate a bank? That's going to go up here. All right. New York State doesn't have anything to do with it. Federal government and interstate commerce, no. Can state governments interfere with operations of a national agency? That's going to be a good one, right? Is that going to be... I'm trying to think of how to phrase that question. They're taxing federal agencies. So where you see the can they tax federal agencies, that's going to go up here with McCulloch versus Maryland, because it is the idea of the bank is created by the federal government, and can the states then get involved with what's going on in the national government? Did Congress have an exclusive right to regulate interstate commerce? That one doesn't really go. And what powers not listed in the U.S. Constitution does the federal government have? Technically, this one can go to just about any of them, but it fits best here with McCulloch versus Maryland. All right, so those are the constitutional questions for that one. Rulings. New York State, no, that's not a problem. Interstate commerce, that's not what we're looking for. Maryland can't tax federal government institution. So we're talking about Maryland and taxing federal institution. But look here also. Even though the Constitution doesn't explicitly state that Congress can establish a bank, the bank is legal because the necessary and proper clause, Article 2, Section 8, gives Congress the power to do what is necessary for the nation to function. And that creating a national bank just gives the U.S. a singular currency and gives it a regulation of the economy. So it's the government stepping in and saying we need to have some kind of hand in the economy, because if we have no hand in all of the state economies, then the state economies kind of clash together. The currency may not be valued the same state to state, And that's no way for a nation to operate. As a nation, if we want to be unified, we have to have a unified economy. Okay. Last one, this one right here. This decision establishes the supremacy of the federal government over the states. That one goes to McCullough versus Maryland. All right, so the states do have power, but the states cannot operate independently without power from the federal government. The federal government is the umbrella under which the state governments function. So it's the question of how do we determine who has more power, and where does that power end? What rights do states have? That kind of stuff. This is the start of the. This is going to be a starting point of the Civil War, because this is going to create a further divide in the question of what power do states have and what power do the federal government have, or does the federal government have? All right. Last one. In 1798, the New York State gave Robert Ogden a monopoly for a steamboat ferry connecting New Jersey and New York. A competitor, Thomas Gibbons, also secured a license from the federal government to operate a ferry between the two states. Claiming that his monopoly rights were violated, Ogden asked a New York state court to forbid Gibbons' boat from docking in New York. Gibbons sued. So this is between two individuals, both who had licenses to operate on interstate, so from state to state. All right, so the constitutional questions are pretty obvious because they're the only three left. Constitutional questions are: could New York State grant a monopoly that operates across multiple states? Did the federal government or state governments have the right to regulate interstate commerce? And did Congress have an exclusive right to regulate interstate commerce, or was this a concurrent power to be shared with the states? So is it fully left up to the states? Is it shared by the two of them? What is the question behind that? Or what is the process behind that? Not the question, my fault. Okay, and then your three Supreme Court rulings. New York State wrote a law that violated the U.S. Constitution. The power to regulate interstate commerce rests only with the federal government, and Article 3 grants Congress the power to regulate interstate commerce. So this is the difference between who builds what kind of a roadway. So if you have an interstate in like it's one that only goes through like interstate, I can only think of like 459, which is down in like the Hoover area. That goes through the state of Alabama and only the state of Alabama. So it is the state of Alabama that has to fix the roadway. It has to regulate it. It has to make sure it's maintained. And anything that happens on that roadway is under the power and protection of the state of Alabama. But then you think of like Interstate 65. 65 goes through a portion of Florida, goes through Alabama, goes up into Tennessee. I think it even stretches out. I think it goes straight up the countryside, but I think it may have a different name when it gets into another state. That's irrelevant. Either way, 65 is an interstate that goes all the way up, and it goes from one state to another. So that is regulated by the federal government. The federal government is responsible for maintaining, repairing, and all of that. Now, they may delegate that to the state to say, hey, each of you needs to fix this portion, but that comes from the federal government. Does that make sense? It's the difference between interstate and intrastate. Okay, I'm going to hope it makes sense.
It does.
Thank you. I don't know who that was that spoke, but thank you. All right, these three analysis questions. I'm going to give you guys the benefit of the easiest thing ever, because I'm going to give you guys the court case that outlines it, which is actually the easiest part, so it may not actually be the easiest part. But I want you guys to explain the answer. Imagine you operated a shipping and packaging service within New York City. You slowly expand to include shipments and deliveries between New York, New Jersey, and Connecticut. after the expansion, could you become subject to regulation by either or all of the states and the federal government? Which court case outlines this? That one should be obvious because it's Gibbons versus Ogden. And then I want you guys to explain it. During the Great Depression, the federal government established many new government agencies, most of which the federal government was not explicitly granted power for in the Constitution. Which of the three Marshall Court cases would have served as an example for why the federal government had the power to create these agencies to stimulate growth in the economy during a difficult period? That's going to be McCulloch v. Maryland. Oh, I can't remember how to spell his name. McCulloch. Ooh, I butchered that. There we go. That looks mostly right. All right, and then that's really all you have to put for that one. And then I want you to answer this one by yourself, because in what way did the Marbury decision enhance the system of checks and balances outlined in the Constitution? So how did Marbury v. Madison allow for checks and balances to take place? And then you're going to come down here. This is up to you guys, because this is mostly there are several different answers that could work for each of these cases. So how did each of these cases expand federal power as opposed to state power? Okay. Questions, comments, concerns about Marshall Court? Okay. All right. The other thing that you guys are doing this week are these chapter 6 summaries, which we will go through these on Thursday. So don't worry about them right now. I can't remember. Is Wednesday A day or B day? I can't remember.
It's A day.
It's A day? Okay. We will not meet on Wednesday. Okay. We will meet on Thursday. We're just going to do like vocab review. Vocab review and states review is what we usually do on Wednesdays anyway. So I'll just make sure that those are posted, because you guys will eventually have the quizzes for a vocab quiz and a states quiz. So I'll make sure I get those up on your Schoology page. All right. Do you guys have any questions, comments, or concerns?
No.
No. Okay. Just the really big thing to take away from the Marshall Court, and I want to say this before letting you guys go. When the founding fathers created the 3 separate branches of government, they created it so that no one area would have too much power, and so that the majority of the power would lie in the Congress, where you have representatives from every state. So representatives that are meant to vie for what the people of their state, their cities, their homes, what they need and what they want. And that's why Congress has the most power. What's kind of started happening over the course, really since FDR got into office, is this idea of the judicial branch becoming a version of the legislative branch. That's not what the judicial branch is for. The judicial branch is for reviewing. It does create laws in that way because like the best case I can think of are there are 2 very controversial ones. One is the case of Roe v. Wade. Roe v. Wade is what created a woman's right to abortion, right? That is technically, it's obviously not stated in the Constitution explicitly that that's something that needs to be handled or dealt with or anything like that. In that case, the Supreme Court technically creates a law that says, yes, this is okay, this is the standard, and then allows the states to kind of go from that standard. So in that case, they do create a law. The other one, and I can never remember the name of this, and it's because it's so recent that I haven't had it shoved into my brain over and over and over, is the is it Hodges versus something? I think it is Hodges versus something. It's the court case on gay marriage, and that one is what the Supreme Court's meant to do. So the Supreme Court says, okay, well, federally, we are saying that people should be allowed to marry who they would want. And states are saying, some states are saying, yeah, that's totally fine. And other states are saying, we're not going to give out certificates for gay marriage. And there's this question of, okay, well, does that fall under state power? Does it fall under federal power? And do the states have the right to bar that constitutionally? And obviously they ruled in favor of the federal government, saying that the federal government has the right to, or the federal government is correct in the fact that you can't tell people who they can and can't marry as far as state governments go. And that's what the Supreme Court's meant to do. That's what they are here for. They are here to interpret the law. They are not necessarily here to create law. And you are kind of seeing a change in that. So I think it's very, very important to stress what the judicial branch is for. They are here to review, not to create. And we're probably going to see more changes to that in the coming years, just because political climate and all that good stuff. But it's going to be something to watch and to pay attention to, so that, when you're sitting there watching TV with your family, you can say, hey, I know what that means. I know all about this in the Supreme Court. So that is everything you need to know. Do you guys have any questions for me before I let you go? If not, you are free to leave and have a good afternoon.